The question is, can you do a plea bargain in a drink driving case? Well, there are two reasons that people sometimes ask this question. The first one is, of course, that drink driving is a serious charge. It carries up to 6 months in prison or an unlimited fine. It's a minimum driving ban, and also you get a criminal record. The second reason is that sometimes people see in books or TV programs or films scenarios where somebody does a plea bargain and reduces the level of their drink driving charge down to something less serious. Now, that is something that happens in some jurisdictions, particularly in some jurisdictions in America. You hear stories about people reducing drink driving charges down to something like reckless driving, but it's not particularly common and doesn't really tend to happen in England and Wales, which is what I'm talking about. So plea bargains where the prosecutor reduces the level of charge are not particularly common, particularly in drink driving cases. So if the prosecutor has a strong case, then they'll tend to stick to their guns and continue with the drink driving charge. There are some scenarios, if there are weaknesses in the prosecution case for drink driving, where the prosecutor might consider a different charge. I'll give you a couple of common examples. I say common examples, examples that do sometimes happen. The first one is if somebody's charged with driving whilst over the limit, but it turns out that there's not strong evidence that they were actually driving or attempting to drive the vehicle, the prosecutor might reduce the level of charge from drink driving to being drunk in charge or being over the limit whilst in charge. That's still a charge that gets you a criminal record. It's still an imprisonable offence, although the maximum sentence is 3 months rather than 6. But the important difference with that is that you can sometimes get 10 penalty points in less serious cases for being drunk in charge of a vehicle, although there is a discretion to disqualify. So that's one, I suppose, plea bargain where the prosecutor might reduce the level of charge. Another one might be if somebody is originally pulled over where the police suspect that they've not been, the standard of their driving falls below the limit. They then think that there's alcohol involved, and they might originally charge them with driving whilst unfit through alcohol. If there are difficulties with the proving that the person is unfit, then in those circumstances, sometimes you might be able to negotiate an alternative charge of driving without due care and attention, which doesn't get you a criminal record, is not imprisonable, and is very often dealt with penalty points. So that's another scenario. There might be some other ones that you could think of too. But in the end, if a prosecutor has a strong case, they will carry on with that case. If there are weaknesses in the prosecution case, if the prosecutor doesn't think that they can prove the case, then very often they'll withdraw the charges. But ultimately, if the evidence is weak, then the way to deal with it is to plead not guilty and take the case to trial. If the prosecutor can't prove the case so that the court are sure, then the magistrates or the judge dealing with the matter will dismiss the case and be found not guilty that way. But that's really sort of outside the scope of a plea bargain.